Hello and welcome to the New Indian Express. The NDA-led government at the center is reportedly preparing to introduce an impeachment motion against Justice Yashwant Varma. This follows serious allegations of a substantial cash recovery at his official residence. This could be the first time a judge is impeached from the Indian judiciary from a motion passed in both the Rajya Sabha and the Lok Sabha. We will be talking to Sanjay Hegde, a senior advocate and a leading voice for civil rights about this case.
Hello, sir. Welcome to the New Indian Express.
Thank you for having me.
Now, in the Justice Varma case, reports suggest that the government is likely to take forward the impeachment motion. What is your opinion on the impeachment motion?
I don't need an opinion. In fact, the judiciary itself has sent it to the government for suitable action. See, the superior judges of the constitutional courts, that's the high courts and the Supreme Courts, cannot be removed from office except through the process of impeachment. Now, there is a very set pattern as far as judges who have to be removed from office are concerned. There will be a motion which is brought before either House of Parliament with a minimum of 50 members. That motion will be admitted by the Speaker and or the Chairman of the House. It thereafter goes for further inquiries. There is the inquiry under the Judges Inquiry Act. The judges and the Supreme Court constitutes a committee of judges, which includes chief justices of high courts as well as a Supreme Court judge. That committee then makes its recommendations to Parliament. Based on those recommendations and everything, Parliament then debates the motion for the removal of the concerned judge. If after a debate in Parliament, the motion is passed in both houses by 2/3 of the members present and voting, then the judge stands removed from office. It must be noted that so far there has been no impeachment motion which has continued till the point that a judge is removed from office, because there have been instances where a motion has been passed in one house, but before it was taken up in the other house, the judge has resigned. Or alternatively, the motion was not passed in a House of Parliament because 2/3 of the members present did not vote for the motion. In the case of Justice V. Ramaswamy, though there was a full debate, the members of the ruling party at that point of time then did not vote. They abstained from the motion. So therefore, there was no 2/3 majority of the people who were present, and thus the motion was lost.
Okay, sir. Now, another factor in this case is that no FIR has been filed against the judge till now. So there was a motion in the Supreme Court which was dismissed, which asked for the filing of an FIR. Now, do you think that this issue needs to be looked at critically? Because there has been criticism that it might have been because he was a judge that no FIR has been filed till now.
See, there is a Supreme Court judgment which says that if you need to take criminal proceedings, you have to take the permission of the Chief Justice of India. So far, I don't think that there has been any application by any investigating agency saying that we need to file an FIR. Please give us permission. This requirement came out of the Supreme Court judgment in the Justice Veeraswamy case. See, what the Supreme Court said was that judges are public servants. They can be proceeded against under the Prevention of Corruption Act, but you need the permission of the Chief Justice of India before you register a case against any sitting judge. That is basically to protect the independence of the judiciary. Because if that kind of protection was not possible, was not there, then any disgruntled litigant could just file a FIR saying that the judge ruled so in this judgment because of X, Y, or Z reasons and alleging corruption. So it is in that context that the protection is given. But I do not think today that as of yet there is any application pending before in the Chief Justice's office saying, Chief Justice, sir, please give us permission.
Okay, sir. Now, if this impeachment motion actually went through, and as we have seen till now, Justice Verma is also refusing to resign, what would you say are the implications and the consequences politically and on the judiciary?
The longer that this drags out, there will be more and more people indulging in all kinds of comment on both the judge as well as the institution. And it may very well be possible that as a consequence of this case, the executive may get a handle to ask for further reforms in the institution, including taking over the process of appointments. There are many of us who believe that all this playing up of this particular case or the amplification of this particular case may only be a precursor to the government bringing in further constitutional amendments or legislation in the matters of judicial appointment. So will there be an NJAC 2 or some other kind of legislation or constitutional amendment? Only time will tell.
Okay, sir. Now, with regard to this case, there has been a lot of criticism, and as you said, the more time it takes, the more criticism is only going to increase. But do you feel, in your opinion, that we need to critically look at how the judiciary handles complaints against judicial officers and the judges?
I am sure that the judiciary takes these complaints seriously. And very often, a lot of things are just said. Any disgruntled litigant can very well say, oh, I lost this case because the judge was got to by the other side. And I must say that also we lawyers may also have our roles in telling clients X reason or Y reason as to why a case was decided in a particular manner. The perception of the judiciary has to be of the highest in the public eyes at all points of time. In this particular case, given the facts of the case, has the judiciary done enough? Well, yes, the judiciary has given the judge every chance to explain himself. It has examined those explanations, and then it says, no, notwithstanding that explanation, we think that now the process of removal from office must be gone through if for any reason that you desire to continue in office.
Okay, sir. Now the National Judicial Appointments Bill, or the NJAC, has come back into the spotlight. It is being headlined by VP Dhankar, who is saying that this bill, which was scrapped, needs to be taken back, needs to come into life again. So, do you feel, in your opinion, that it should be done as Mr. Dhankar is saying?
See, the NJAC Act was brought in by a constitutional amendment. It was a constitutional amendment which was unanimously passed by all parties in Parliament, save one dissenting member, that was the late Mr. Ram Jethmalani. Notwithstanding near unanimity, the Supreme Court found it unconstitutional and struck it down. It was not as if it was some enactment that the government thought of bringing and then it did not bring about. It was struck down by the Supreme Court for particular reasons which rendered that particular version unconstitutional. Nothing prevents Parliament from again bringing a constitutional amendment. But I do not know whether this time they will have the unanimity of the past. And if they make modifications in the previous model, will those modifications also be held to be unconstitutional? We do not know. The vice president, who has been a senior advocate in his time, is entitled to his opinion. But I would greatly urge that the independence of the judiciary, including its independence in recommending the appointment of judges, should be protected. Otherwise, we can go back to the good old days of where the late Mr. Ram Jethmalani said that there are two kinds of judges, those who know the law and those who know the law minister. So do we want to go back to those days? Or is there a happy via medium to be found somewhere?
Okay, sir, thank you so much for sitting with us. Thank you so much for talking at length about so many topics pertaining to this case, which needed a lot of clarification. Thank you, sir.
Thank you.